Okay. I hope my screen is visible. I hope I am visible. I hope I am audible.
Mhm.
I Okay. Thank you so much. Um, I am audible, right? Because I can't hear myself.
Yes, ma'am.
Okay. Thanks, Anushri. Okay. Okay. So we stopped at types of bail. Now, there are about, as much as I know, there are about three main types of bail. There's a regular bail, there's an anticipatory bail, and there's an interim and a default. Sorry, four types of bail. And all of these other subcategories are just so that bail drafting is a little easier. We've done an anticipatory bail. We are going to do a regular bail. Uh, I think so. White collar crimes is what you will be dealing with, and it is a bailable offense. Sorry, a non-bailable offense. So accordingly, a draft will be sent to you.
কি কি তুইও
As much as I love kids, Samia, please mute yourself. Thank you. Um, okay. So, moving on, our main topic, regular bail. Now, regular bail is as stipulated under Section 437 and 439 of CRPC, is granted to an accused who is in police custody or judicial custody. This type of bail is different from an interim or anticipatory bail and is sought after the arrest of the accused. Now, regular bail can be of two types: regular bail granted in a bailable offense and regular bail granted in a non-bailable offense. Now, there are certain conditions which need to be kept in mind, and there are certain key provisions which need to be kept in mind, and there's a certain procedure for obtaining this kind of bail, all of which we'll be discussing in the subsequent slide. Um, so basically, a regular bail is stipulated under Section 437, which says that bail in non-bailable offences. So that is where usually a regular bail is granted in a non-bailable offense. Bailable offense is very rare that people will ask for a regular bail. They usually go in for interim bail or a default bail or something like that. Now, interim bail and anticipatory bail are usually before the arrest of the accused. Now, regular bail is once the accused is the inside the detention or in detention or has been detained by the detaining authority or the criminal enforcement authority or the judicial authority in some cases. Now, there are certain key provisions of the particular kind of bail, regular bail. Section
I'm sorry to
430.
interrupt. I'm
Yeah.
sorry to interrupt. Can you please differentiate between the judicial custody and the police custody? Sorry.
Okay.
Yeah.
Police custody is usually, as we all know, is when a police officer takes you in, puts you in jail, and handcuffs are not allowed unless in really, really exceptional circumstances. Now, a judicial custody is when you are ordered by the court not to move. You're placed under house arrest. You're given certain travel restrictions. You can't go to this in this country by an order of the court. Any kind of detention or holding in by the court through an order is called a judicial detention. Now, a judicial detention, let me just give you a proper definition. Um, okay. Yeah, so like I already mentioned, it is on the basis of the orders of the court. Now a person can be placed on house arrest. He can be put in the jail by an order of the magistrate. Now, judicial custody is usually by an order of the magistrate. Now, police custody is if the police feels it necessary to put the person in detention. That's when they arrest the person and they put them in a prison cell. That is the difference between the two. I hope it's clear. Moving on, key provisions Section 437 and 439. If anybody else has any doubts relating to judicial and police custody, we'll discuss with it at the end. I just want to finish this portion of and then give you your task so that people who have no doubts can start leaving. Okay, Section 437 is bail in non-bailable offences. Now, a regular bail under Section 437 can be granted to a person accused of a non-bailable offence. Now, in this case, the court considers certain factors like nature and gravity of the offence, the antecedents of the accused, the possibility of the accused fleeing or running away, or things like that, and the likelihood of tampering with the evidence um, and the accused's criminal history as well. Now, these are certain factors the court keeps in mind before granting or not granting a bail. Now, moving on, Section 439 is special powers of High Court or Court of Sessions regarding bail. Now, if you want a proper reading of it, I will send you the bare provision. You can go through that as well. Now, it says that the high courts and courts of session have the authority to grant bail under Section 439. Like I already mentioned, Sessions Court are the first court that you approach to get a bail. After that, if you want to go on appeal, it can go to the High Court or even directly to the High Court. But from a High Court, you can never come to a Sessions Court. That's like lower in authority. So that is not possible. Um, then both of these courts, the High Courts and the Sessions Court, consider the same factors as are already mentioned in Section 437, along with the strength of evidence against the accused. Now, Section 439 gives power to the Court of Sessions as well as the High Court to hear the prosecution side regarding the bail. Now, there are certain times where the judge himself is not sure as to whether or not he wants to give a bail. So he gives an option to the prosecution to present their averments or their arguments against granting the bail to the accused. That is also something which can be done by the Court of Sessions as well as the High Court. Now, moving on, there's a certain procedure that needs to be followed to get a bail. First of all, is the application to the court, the accused usually, or their legal representative, which is usually their advocate or their legal representatives like their son, their wives, their husbands, their mothers, whoever is legally representing them in the court, files a regular bail application before the appropriate court. As we know, the appropriate court is the Court of Sessions or the High Court, unless in exceptional circumstances, the bail matters can also be taken up by the Supreme Court. It usually doesn't go to that extent because usually the decision of the High Court, unless the High Court feels that it is something of public importance, it will not send it further to the Supreme Court. Now, next is notice to the public prosecutor. Now, the court serves the notice to the public prosecutor, giving them an opportunity to present their case against the grant of bail. Now, the public prosecutor, as we already know, is the one who represents the one against the accused. Now, for example, if I'm the accused, the public prosecutor will be my opponent or will be my opposite party. Or if I have a legal representative, for example, if I have an advocate. Now, my advocate is not a public prosecutor, but who I am accused of committing an offense against, that individual has a public prosecutor, and their cases are usually run by the state. So, keeping that in mind, a notice is sent to the public prosecutor, giving them the opportunity to present their case against the grant of bail. Now, this happens only in the regular bail. This does not happen in anticipatory bail or in interim bail for that matter. The public prosecutor is allowed to present his averments to the bail or his his points against the bail or his case against the bail. Now, now the court conducts the hearing of the application, where both the defense and the prosecution present their arguments. Now, because this is an application that is filed by the accused, the burden of proof is on the accused. So the accused will first give them all their reasons, give the court all his or her reasons, saying that this are the reasons why I should be granted a bail. These are the factors which I think might give me a bail. These are the conditions on which I will take a bail. And in case I don't take a bail, in case I don't follow the bail or don't go through with the bail, This is my surety. These are, I think, one or two sureties. I'm not sure. I will get back to you on that. I think you have a surety. There is a surety. I'm not sure if it's one or two. Uh, so there's a surety as well as the advocate also sign on behalf. So now on in the hearing, you again have principles of natural justice which need to be followed. Um, right to be heard, right to present arguments before the judge, and right to reason decisions. Now, all of these three need to be kept in mind. Next is consideration of factors. Now, the court considers various factors such as severity of crime, as I've already mentioned, the severity of crime, likelihood of the accused absconding, possibility of interference with the investigation. Then you have accused's criminal history. Then you have strength of evidence. Then you have, the decision or the application of mind by the court. All of those are factors which are taken into consideration before granting or not granting a bail. Next, you have grant or denial of bail. Now, based on the arguments and the factors as well as the um, considerations, arguments, conversations, all of those, the court decides whether or not to grant a bail to the accused. Now, there are certain conditions which need to be fulfilled before. Just one second. Sorry about that. Now, there are certain conditions which are required before granting a bail. As I already mentioned, surety. Now, the court usually requires the accused to provide a surety who is a financial guarantor that the accused will appear at the trial. Now, there is something called the surety bond. Surety bond is something which a surety signs on behalf of the accused, stating that if the accused does not appear, I will pay the court this much amount on these dates. On if he doesn't come on one hearing, this is the amount I'll pay. If he doesn't come for consecutively three hearings, this is the amount I'll pay. Now it is on the court as to whether they will take that money which they get because of a surety, or will they give it to the victim of the accused if he's already proven guilty. Moving on, there's restrictions on travel. Now the court may impose restrictions on the accused's travel and require them to surrender their passport until the trial is completed if if the offense is of such magnitude, of such nature, that it is of very so it is very much necessary that they must surrender their passport. Now, giving you an example, if Vijay Mallya, Nirav Modi, all of those people who have done financial frauds on the country, um, had they been asked to surrender their passport, they would still be in India. We could have still prosecuted them. So that is the evolution point where the court realized that, okay, we need to keep their passports if it's a huge amount of money involved, or if it's a huge case of murder, or if it is a very, 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 very heinous crime that the accused had committed. Their passports need to be surrendered to the um, courts. Now, sorry, there is instead of I've written surety twice, but the third condition is reporting to the police. Now, the accused may require to regularly report to the police station as a condition of bail. Now, there are every place has a police station or the head police station. The accused may be asked to um, report to the police station, which is the nearest to his house or her house, and he must. I think there's a signature book where you need to. I think there's a signature book where you need to sign. So you sign and you tell them that okay, hey, I am still the accused, yeah, but I've not done any other crime apart from the one which I have accused, which I have been accused of doing. So moving on. In conclusion, regular bail is a crucial legal remedy that ensures the rights of the accused while safeguarding the interests of justice. Now, there's a careful consideration of multitude of factors, and the decision of the court plays a pivotal role in the pre-trial stage of criminal proceedings. Now, the aim of this particular kind of bail is to strike a balance between personal liberty of the accused and the societal interest in prosecuting crime. Now, this is your problem. I will be sending you a Word document by tomorrow morning. The facts of the case are Mr. Raj, a 35-year-old individual, has been arrested in connection with a robbery that occurred at a local convenience store. Police claim to have substantial evidence linking Mr. Raj to crime, including CCTV footage and eyewitness account. The offence is non-bailable under the relevant sections of the IPC. Now you are Mr. Raj's legal representative and you need to file a regular bail before the sessions court. Now, the defense argues that Mr. Raj is a first-time offender with no previous criminal record and is a responsible member of this community. They claim that the evidence against him is circumstantial and can be contested during the trial. The defense also asserts that Mr. Raj has a stable job and family to support, and there is no risk of him fleeing the jurisdiction because all of his family stays in the particular jurisdiction. Now, here, jurisdiction, you're free to decide what your jurisdiction you want. Um, Now, the prosecution's response. The prosecution vehemently opposes the bail application, presenting the CCTV footage and eyewitness statements that allegedly placed Mr. Raj at the scene of the crime. They argue that the evidence is strong and, and that Mr. Raj, if released on bail, may tamper with the witnesses or even abscond. The prosecution also points out the severity of the offense and potential impact on public safety. Now, this is you are for the accused. Please keep that in mind. This is just so that you have something to, I don't know, like it's something that I thought was relevant. So um, this is what the prosecution will probably say when the stage of the application comes to hearing. So these are the arguments you need to make. Now the court considers several factors. Number one, nature of offenses, strength of evidence, defendant's character, likelihood of absconding, and tampering with the witnesses. Now there are two possible outcomes: bail granted or bail denied. If the court finds that evidence is not strong and that Mr. Raj is not a flight risk and that he is unlikely to interfere with the investigation, the bail may be granted. Now, it is your duty as his advocate or as his legal representative to make sure that you make it look like he is not going to do anything. He is a very responsible citizen of the society. He is a very respectable citizen of the society. Although he's 35 years of age, he has a well established business, a business or a job or whatever else you want to include. Um, yeah, so yeah, Mr. Raj has a stable job, so you can include that he's a respectable citizen, even though he's 35. He has a well-established commercial enterprise, etc., etc., etc. Now, what you need to do is um, okay, so what you need to do is basically you need to draft a bail application for Mr. Raj, stating that he is innocent and he's been um, falsely accused of the crime and that he is to be released on bail and that he will always appear as and when the trial is conducted. All of these need to be kept in mind, and all of those you need to put in your draft. Um, I will be sending all of the documents, all of the Word documents, all of the PPTs and your tasks and your samples by tomorrow night. Your task submission deadline. Since we've started on Tuesday, I will give you the deadline on Sunday. Sunday 5 p.m. is your deadline. Um, and Sunday morning 10 a.m. we will have our next session. We could not have it this Sunday because it's Diwali and I did not want to disturb anybody. So that's that. Please quickly start submitting your task. Please read the PPTs, go through the documents. If anybody else wants extra notes or anything, you are always free to text me. Um, yeah, thank you.